Good afternoon, everybody, and welcome to another webinar from the TUC. I'm Anna from TUC Education, and I'm joined today by a record-breaking 4 speakers. We've never had this many people. So just very briefly, I'll tell you who they are. We've got my colleague, Nikki, the TUC Women's Officer. We've got Ian from Equity. We've got Anthony from the HSE, and we've got Kate from Maternity Action. And we'll be coming to each of them in turn very soon. Just to remind you, we've got live captions on this webinar. If you want to follow along with those, press the green button that's at the bottom of the video screen. That will open a new window with captions in it that you can follow along with as we're speaking. You can ask a question of our panel. If you'd like to post a question, click the Ask a Question button, which is right at the bottom of the screen. We can't promise to get to every question because we normally get quite a lot, but we will answer as many of them as we can. But don't worry, if we don't answer yours, we will take that question into consideration when we're writing guidance for reps. As ever, we've got our lovely chat panel on the right-hand side, and it's great to see it's so busy already with you introducing yourselves, telling us where you're from. Please also use that area to exchange some tips and ideas, or if you've experienced this issue in your workplace, tell us about it, because we really like to hear what's going on in workplaces. As ever, we're recording this webinar, and we will send a recording out to everyone who's registered, along with any resources or links that our speakers mention. So don't worry if you miss any of it or you miss a resource. We'll make sure you get sent it all either this evening or first thing tomorrow. So today we're going to be talking about how we as workplace reps can protect our colleagues who are pregnant and support new mums when they return to work after a period of maternity leave. And there's some important changes that we're really going to focus on here, which is about protecting the health and well-being of these members. So first of all, I'm going to hand over to my colleague Nikki, who's going to just introduce this subject for us and give us a little bit of background. So Nikki, it's over to you.
Great, thank you, Anna. And yes, thank you everyone for having me here today. It's really great to be here to talk about this really important issue. As Anna said, I'm Nikki Pound. I'm the Women's Officer at the TUC, for those of you who've not met me yet. So yes, risk assessments for pregnant workers and new mothers. This has always been a key issue for trade unions. I think it's important to highlight that 60% of our members are women. So this is an issue that will impact many of our women members at some stage. And it's something that our reps consistently raise as a key area of casework for us. We know from research that employers have not always been clear about or fulfilled their legal responsibilities for health and safety in relation to pregnant workers and new mothers. For example, there was some research from the EHRC in 2016 that found that 41% of mothers reported a risk or an impact to their health or welfare in the workplace. And this rose to 50% of those in agency, casual or 0 hours employment. In that research, they found that 1 in 25 mothers had left their jobs because of risks in the workplace not being tackled, which the HRC calculated could affect as many as 21,000 mothers each year. And most women, around 72%, were left with no option but to continue working in an unsafe working environment. And as has been the case with many things, the pandemic shone a particular spotlight on the health and safety risks facing pregnant workers and new mothers. As I'm sure many of you as reps will know, there was some conflicting and confusing advice from the government, and that was compounding the problem as well. And it was clear from what you were telling us and the research that we did that many employers were not properly considering the health and safety of their pregnant and breastfeeding employees. The TUC did a survey in June 2020 of nearly 3,500 pregnant workers and new mothers, and we found that 30% of the pregnant women that we surveyed felt that very or somewhat unsafe at work during COVID. 2 in 5 pregnant women in our survey had not had a health and safety risk assessment. And of those workers in our survey that had had an individual health and safety risk assessment, almost half said that their employer did not take the necessary action to reduce the risks identified. and over a quarter of pregnant women in that survey said that the risk assessment did not include the additional risks posed by COVID at the time. Many were being forced to take sick or unpaid leave by their employer, or feared that they would just have to leave the workplace altogether. And more recent research from Maternity Action in 2021 found similar health and safety issues, but I will leave that to Kate to cover. So we know pre-pandemic, during the pandemic and post-pandemic, ensuring that pregnant workers and new mothers have their health and safety specifically considered by employers is an issue. The existing guidance already said that employers did have a legal responsibility to consider risks to pregnant women, new mothers, and women of childbearing age in their general workplace risk assessments. But as the TUC, we decided to seek legal clarification of the law, as we and other stakeholders felt it had been established that workers were entitled to an individual risk assessment once they notified an employer that they were pregnant. So we commissioned a case law review to check whether that had indeed been established, and that employers must carry out an individual risk assessment once they are aware an employee is pregnant, breastfeeding, or returning to work within 6 months of giving birth. And the legal instruction found that that was indeed the case. And just to say that the case law examples are included in the brilliant toolkit that Kate will take us all through in a bit. But the TUC legal advice that has been shared with affiliate health and safety officers, national health and safety officers and equality officers. So do please speak to them if you want more detail. So working with affiliates, Mat Action and other stakeholders, we shared this legal advice with the HSE, who I'm really pleased that we've got here today, and the HRC, and worked with them to update the guidance on employer responsibilities in doing individual risk assessments and in workers' rights on making sure that they can access that right. So I'm pleased to say that this has now happened. The guidance has been updated, which Anthony's going to take you through. So now for us, it's really important that as trade unions, we ensure that employers know their responsibilities and that workers know their rights, and that we help enforce them. And that's why we're all here today. So I don't really have much more to say other than to say I'm going to hand this over to Anthony now from the HSE, who will talk us through the new guidance that they've issued.
Thanks so much, Nikki. And I think a really important point from the things you said is that, like so many things, the pandemic really brought this to light. And we all know there are lots of things that the pandemic showed up, you know, to say the least. But Anthony, can we just hand over to you now, as Nikki said, from the Health and Safety Executive, to talk us through the new guidance.
Great, thanks very much. Good afternoon, everyone. My name is Anthony Halewood, and I'm a policy advisor on HSE's Vulnerable Workers team. I would like to thank Nikki and all of our colleagues at TUC, Maternity Action, and everyone else for bringing this issue to our attention, and for all of their great work in helping us to make our new guidance as helpful and as useful as it can be. HSE don't actually receive a large volume of concerns relating to pregnant women and new mothers. Complaints making reference to pregnancy and new mothers make up just over 0.5% of the total of the concerns received by HSE. But we do know that this can be a challenging, worrying, but exciting time for many workers, both inside and outside of work. And some employers do not understand their obligations as well as they should. So we took this opportunity to refresh the whole of the guidance, updating the language used, making it easier to understand and clarifying certain points. Pregnant workers have special protections in law, and our updated guidance explains those protections, including the recent changes which have been brought about by changes to case law. The Health and Safety at Work Act sets out the general obligations and duties that employers have to their workers to protect them from harms arising from the work activity. The Management of Health and Safety at Work regulations are more specific, and they set out the requirements to complete a risk assessment, as well as rights particular to pregnant workers around maternity suspension, risk assessment, and night work. And finally, the Workplace Health, Safety and Welfare regulations set out that pregnant and breastfeeding workers must have somewhere suitable to rest. So employers must still consider the risks to women of a childbearing age as part of their general workplace risk assessment, as was the case prior to these changes. The new part is that once an employer has been notified that a worker is pregnant, has given birth in the last 6 months, or is currently breastfeeding, they must complete an individual risk assessment. Employers should review their general risk assessment for any risk that they already know about. They should then talk to their pregnant worker to sort how circumstances around the pregnancy that would affect their work. Employers must also take account of any advice given by a doctor or midwife. Provided the worker has no objections, the trade union or safety rep should also be involved in that conversation. It's also really important for employers to regularly review the individual risk assessment and keep it up to date as the pregnancy progresses, if the work environment changes or if there are any changes to the work activity. The employer should then share the findings of this risk assessment with the worker and their safety representative or union rep. We've updated our guidance to give more information on some of the common risks faced by pregnant workers as well. But it is really important that employers think about the specific hazards and controls that their business needs, as well as the individual circumstances of each pregnancy. Some of the most common risks will include standing or sitting for long periods, working with shocks or vibrations, work-related stress and fatigue, and exposure to harmful substances. The camera's just disappeared. Can you still hear me?
I've actually just turned your camera off a minute, Anthony, because I think your signal's wobbling a bit and you keep dropping out. And the best way to protect the audio is to turn your camera off, if that's okay. Can you just go back to the beginning of the sentence you were on, and I'll try and bring you back on the screen visually, if that's. But we really want to hear what you've got to say. Are you still there? Let me see if. Okay, we might have to come back to Anthony in a minute because he's there, but we can't hear him at the moment either. Okay, right. Really sorry about that. We will do everything. I'll do everything I can to bring Anthony back, but because we really need to hear this guidance from the HSE, which he started to cover. I think in the meantime, I'm going to move over to Ian, who is from Equity, just to hear about some of the things that Equity have been doing for their members on this issue. Anthony, great to see you back. I think I might just. Okay, great. You've gone again. Let's just see how it goes for a minute. Let's just go to Ian and hear about what Equity have been doing, and then we'll come back to you to hear about the HSE. So, Ian, can you tell us what you've been doing for your members, please?
Yeah, I will do, definitely. But what I'd like to do, if it's okay, is, because I'm conscious the reps here from a very good, wide, diverse body of unions, there's a big difference here that I want to talk about, and I'll explain it more in a second. But good afternoon, everybody. My name is Ian Manboard. I'm the Equalities and Diversity Officer at Equity, the trade union for creative workers across the entertainment industry. So our members are actors, performers, singers, dancers, comedians, very wide, diverse body of people. When our members are working, they have the employment status of worker. It's an important distinction, this, because just looking at the unions that are represented here this afternoon, UCU, Unite, PCS, your members will conventionally be employees. And for the purposes of this seminar, it's really important just to separate out that the rights of employees as pregnant workers, although they're not great in the UK, like many employment rights, they are preferential to those who are workers. So I just need to be clear, Anna, that I just want to touch upon where the similarities are, diverge onto employees and then workers, and then where we sit in terms of advising our members. So Anthony's going to carry on with that focus on health and safety rights. So just to start right at the very beginning, whether you're an employee or a worker, there's two fundamentally important areas where your rights are similar. Anthony started to talk about them. They are the health, safety and welfare protections. And as Nikki said earlier on, whether you're an employee or a worker, it's the fundamental right to an individual risk assessment. And then the related duty on the employer thereafter to put in place those measures to avoid risks. Similarly, whether employee or worker, you have a fundamental right to protection from unfair treatment and definitely unfair dismissal that relates to your pregnancy also. Where the rights of employees then diverge to become more preferential to workers is notably, this is something that Kate will touch upon later on, is the right to maternity leave. 52 weeks of paid maternity leave, paid using statutory maternity pay. And similarly, employees have the right to reasonable paid time off for antenatal care. There are three key messages that I'd want to say to the reps who are here this afternoon, which reflect, as Nikki had mentioned earlier on, reflect our primary concerns around the mistreatment of pregnant workers, whether employee or workers. The first is around the problems to do with unfair dismissal during pregnancy. It is a major problem that we have in the UK. It's predominantly negligence on the part of employers. The second thing that's a huge problem for us in the trade union movement is unfair selection for redundancy. Typically what happens is a woman's put in the redundancy selection pool while she's on maternity leave and then is unfairly selected. If one of your members is put in the redundancy selection pool, then you must automatically challenge that, because it's likely to be the start of a process of unfair dismissal. And the last thing, and this is very much wrapped up in what Anthony will continue to talk about, is to remember the right of employees to be suspended from work for maternity-related reasons on full pay, should that risk assessment show that the risks to the woman and the fetus cannot be satisfactorily protected. Many employers resist that period of suspension with pay, but three big things to look out for that our members, regardless of whether they're employees or workers, face. And then three key things, Anna, that we always talk about with our members as workers. The first is that our members aren't entitled to statutory maternity pay. They're entitled to maternity allowance. Our members are not entitled to statutory maternity leave. We negotiate with employers, whilst our members do not have those statutory rights, to get them bound within the framework of contracts. So our members usually have the entitlement to leave and maternity allowance pay within their contract. So we ask our members to talk at a very early stage, does the contract reflect your right to maternity allowance and a reasonable amount of leave? The second thing is, we want our members to be aware of their fundamental right as workers to claim statutory maternity allowance. And the very last thing we want our members to do, as self-employed workers, they do self-assessment returns and they pay Class 2 national insurance contributions, is do a full social security review via the DWP to make sure that you're fully paid up for maternity allowance and the other welfare rights that you're entitled to. And what I'd underline is, although your unions represented here have some very good resources, I'm aware of that, whether it's UCU or Unite, I would thoroughly recommend, and I'm not just saying that because Kate's here, the Maternity Action website. It's one of the best resources, certainly for employees and workers also. But I'm going to ask my colleague Tanya at the TUC to share a link to one of our successful cases that we won last year against a producer who refused to implement reasonable adjustments, leading to our member losing work. The last three links, and then I'll end to hand it back over to Anthony. We've created a dedicated video with Maternity Action for self-employed workers to focus on the pregnancy and welfare rights. You're also going to get a link for self-employed workers to parental and childcare rights. And then very lastly, from our sister union, the MU, a link to their guidance on health, safety, pregnancy and the return to work as well. So I know I've run through that quite significantly, but I just needed to separate out where the differentiation is between employees and workers. But you will find, obviously, a lot more detail in those links that I've sent through there. So I've kept it brief, Anna, because I know we've got quite a few speakers and we need to go back to Anthony. But hopefully I've not done it in such a way that I've left anybody confused. But we can deal with that if there are any questions later. And I thank you very much.
Thanks so much, Ian. And I think what's really helpful is to actually hear that perspective about people who might not be, the standard employee. Maybe on our webinars, we do focus a lot on that. So it is really great to get the perspective for union members who aren't in that situation and perhaps rely on different rights. Okay, Anthony, you keep the screen keeps going a bit crazy, but I'm going to try and just hand back over to you to just finish off the guidance for employees before we move on to Kate and maternity action. But so thank you for bearing with us. So if you could just go back to maybe one sentence, if you can remember one sentence from where you were before we lost you before, that would be great.
Great. Let's hope this works. It wouldn't be one of these webinars without some form of technical difficulties, and it's definitely my fault this time. So I think it was sort of where I left off. We were talking about the most common risks for pregnant workers, which I'd say include standing or sitting for long periods, lifting and carrying heavy loads, working at height, shocks or vibrations, work-related stress and fatigue, and exposure to harmful substances. But it's really important that they're just some of the most common. Each business is going to have its own specific hazards and require its own specific controls, and each individual pregnancy is going to be different, so there isn't going to be a one-size-fits-all here. There is a long-standing requirement, and what Ian alluded to before, that where reasonably practicable actions will not control significant risks, the employer must follow a set process. And first, they must have you can still hear me?
You disappeared for about 10 seconds again. Okay, try and carry on for now. But if it keeps happening, what we'll do is we'll make sure that the information that you're talking about gets included in the resources anyway. So let's just try again, because I don't want to, you know, just sort of
take up too much time with my
write you off. No, but I don't want to right. It's just your internet connection. It just keeps wobbling. I can see it happening. But let's go. Let's go now.
So the longer conditions.
Okay, I think for now
on the same terms and conditions, including pay.
Okay, did the screen just go crazy for everyone? Mine just did a crazy thing. Right. Okay, let's, for now, Anthony, because I can't see it being stable for long enough, let's just give it a minute or two, and we will definitely share your resources with the audience. A viewer has just said that maybe one of the reasons we're having this problem is that there's a sun flare affecting satellites and the internet and phones and things today. So maybe that's what's caused it. So for now, I am gonna just keep you here, Anthony, but we're gonna hand over to Kate to talk about the guidance that Maternity Action have produced in conjunction with the TUC. So I think it's going to be some really useful guidance for workplace reps in their role supporting members. So Kate, over to you.
Okay, thanks very much. And thanks again for inviting me to this webinar. It's great to be able to launch the new toolkit to so many reps. My name's Kate Moran and I'm a policy officer at Maternity Action. For those of you who don't know, Maternity Action is a UK-wide charity, and we work to promote and enhance the rights of pregnant women, new mothers and their families, both in terms of employment rights, but also in terms of social security and access to healthcare. One of the services that we run is a telephone advice line, and that's a free advice line run by solicitors. And any pregnant woman who's facing discrimination in the workplace or has concerns about what's happening at work can phone our advice line for some help. And we also have a number of caseworkers who also take on cases. So at the start of the pandemic in early 2020, our advice line was absolutely inundated with calls from pregnant women who were really concerned that their employer wasn't doing enough to protect the health and safety of them and their baby in the workplace. The kinds of concerns that were being raised were that risk assessments either weren't being carried out at all or were being done poorly by managers who had no training or expertise in the area and didn't really know what they were doing. And that's if they were lucky enough to actually have a risk assessment. Women were incorrectly being sent home on sick leave or unpaid leave, and in many cases this had a severe impact on their entitlements to statutory maternity pay. So if they ended up on unpaid or sick pay during the crucial 8-week period, which is used to calculate their entitlement to statutory maternity pay, then that could have a really negative impact and mean that they were now only entitled to maternity allowance through no fault of their own, which meant that many women lost thousands of pounds as a result. There was little awareness of the rights of women who are employees to be suspended on full pay if the employer is unable to provide suitable alternative work or make reasonable adjustments. And many employers, again, were either not aware of it or chose not to make their employees aware of it. So in 2021, Maternity Action undertook a survey of women who'd been pregnant and working since the start of the pandemic, and our findings were very similar to the ones that Nikki referred to by the TUC. Over 2/3 were very or fairly worried about catching COVID in the course of their work. 59% had raised concerns with their employer, but 1 in 5 said that their employer took no action to protect them. And over 1/3 said that they were worried that their job would be at risk if they took leave or if they pressed their employer to do more to protect them in the workplace. So as I say, this led to the publication of a report by Maternity Action, which is called Unsafe and Unsupported, and that's available on our website. We published that in December 2021, and it contains the survey results. It also includes a number of recommendations for action that the government and others can take, including employers, to better protect the health and safety of women in the workplace when they're pregnant or coming back from maternity leave. The recommendations and the guidance was actually that the HSE should update their guidance to reflect the fact that women are entitled to a risk assessment, pregnant women are entitled to a risk assessment, and not just to be part of a generalised risk assessment. So we were really pleased that the HSE have taken those steps and have updated and amended their guidance. Again, as Nikki said, these issues were highlighted by the pandemic, but they weren't new. Our advice lines have had many calls in the past about health and safety issues, and it is a really big concern. There's clearly a lack of access for women to clear, understandable guidance on their health and safety rights in the workplace. And as Ian was saying, that's even further complicated by the different rights or lack of rights that apply to women who are classed as workers or who are in insecure and casual work. So as a result of all this work and the queries that we were taking from women, we decided that what was really needed and would be useful would be a toolkit for trade union reps to help them to understand the rights of their pregnant members and new mothers coming back to work, so that they could have really clear information and some kind of checklists and reminders about what they needed to do to protect those rights. So I'll just give you a quick run through of the toolkit. The toolkit is now up and available on both the TUC website and the Maternity Action website. We've broken it down into 8 chapters, so I'll just give you a brief overview of what each chapter contains to give you an idea of what kind of resource it is and how you can use it. The first section covers employers' responsibilities, so the action that employers need to take, and the woman's responsibilities in terms of informing the employer about her pregnancy, at which point the rights to health and safety protections kick in. The second section very much reflects what Ian was talking about. So this highlights the different rights that apply to women who are classed as workers and are in insecure or casual work, and highlights the areas in which they don't have the same kind of protections, so including things like rights to time off for antenatal care. The next section contains a checklist for reps. So what we've done is set out a kind of checklist that you can use, so checklist that you can work through with them to cover all the kinds of areas that you think you need to. So the kinds of things we talk about are confidentiality. So it may well be that the member doesn't want other people, including her employer or line manager, to know that she's pregnant. And you can help by doing things like accessing any local agreements, HR policies that are relevant, so that the woman doesn't have to and kind of give away the fact that she's pregnant if it's not ready to do that at that time. It talks about things like checking if she's got any immediate health and safety concerns, what they are and how they can be mitigated. We advise reps to also plan to have regular meetings with pregnant members throughout their pregnancy, just to check that everything's being done as it should, that the risk assessment's been done, that the reasonable adjustments and changes that are needed have been made. And we also advise you to ensure, as Ian said earlier, that trade union reps are involved in any risk assessments that are undertaken. The next section covers guidance on risk assessments. So in this section, we explain what they should cover and what should happen if the employer can't provide suitable alternative work or safe working conditions. So this explains the rights to maternity suspension, the case law, which is the Oteros Ramos case, on which those rights are based, so that if the employer does start to say, well, I don't have to do this, you've got the arguments there to be able to explain, yes, you do, and this is the evidence to show that you do have to do this, as well as the new HSE guidance. We talk about the types of risks affecting pregnant women. So as Ian said, as Anthony was saying, there are a whole host of different risks that can affect pregnant women particularly. And we explain the impact on the woman and the baby of those kinds of risks. So things like tiredness, stress, heat and cold, standing, working long hours, violence and working alone, and harassment. The next section is specifically around breastfeeding. So it sets out the kind of rights, albeit limited, that women have to be able to continue breastfeeding in the workplace. And again, we link into things like the HSE guidance and explain what you can do to try to ensure that the facilities are there to enable her to continue breastfeeding or to express milk in the workplace and store it. Then next, the second to last section is a checklist for reps when you're negotiating or updating local health and safety policies and other related policies. So again, we give you a whole kind of list of things to think about. And it's not just necessarily your pregnancy or maternity or health and safety policies that you need to look at. But for example, does your local bullying and harassment policy specifically include pregnant women and breastfeeding mothers? Does the sickness absence policy make it clear that pregnancy-related absences should be recorded separately and not used for selection for redundancy or disciplinary action? Could the employer improve facilities for women who are breastfeeding or expressing milk, and what kinds of things could be done? Are risk assessments carried out when a woman tells the employer that she's pregnant? And is there some kind of formal commitment within your maternity policies or health and safety policies that the employer will do that, so that the women know they've got that right and they can approach the employer fully confident that that will be done? And are they regularly reviewed during her pregnancy as her shape changes? Does this include things like PPE and uniforms? Because again, they're going to need to change as a woman's pregnancy develops. Is refresher training available on return from maternity leave? Because again, this can help reduce stress for the woman if she's had a long period away from work and is a bit nervous about coming back to work, along with all the kind of stress of leaving a new baby. The final section is kind of a list of references and further reading. So we've got links in there to the Maternity Action's 50+ information sheets. And thank you very much, Ian, for what you said about those. I previously worked for a trade union and I use them myself all the time. They're really well written by our solicitors, really clear, really easy to understand, and cover the whole range of issues throughout pregnancy and all types of workers on different kind of contracts. And we've also got links in there to several of the TUC publications, which again are relevant and cover pregnancy and maternity discrimination, ventilation, and so on. So that's a really quick run through of the toolkit. As I say, I hope you find it useful. It's designed in such a way that you can print off sections and give them to the pregnant member or new mother, so that again she can go away and find out more about her rights. And it's got links to other organisations and information that she might find helpful, such as the RCOG guidance around the virus and being vaccinated. So as I say, I'll stop there because I know we're short of time, but hopefully that's just a quick run through and gives you a good idea of what to expect from the toolkit.
That's fantastic, Kate. Thank you so much. And it sounds like that the toolkit is going to be really helpful to reps in their role because it covers such a comprehensive range of things. I think the point that I noted as most interesting was that how reps should be aware of what other policies might be affected by pregnancy or returning from maternity leave, for example, bullying and harassment. And that's a really important point, because we should always remember that a rep's role is holistic. It's not just about one thing. It's across the workplace. So about considering all of these things. I don't know whether you've kept an eye on the chat, Kate, don't worry if you haven't, but people are saying they love it already. So even though they might have just read a few pages, it's great to see it so well received. Right. I don't know whether Anthony can still hear us, but we're going to move on to some questions, I think, for now, because I think he is struggling with his connection. So I'm going to actually take the first question, which I'm going to put to Ian, because it's about freelance workers. So hopefully this is something that you can answer a bit more easily than the others. So our viewer asks, for freelance workers, what guidance or advice is out there, or do you recommend, on disclosure to potential future employers regarding pregnancy?
It's a really good question. As many of the reps will know, Kate will know, typically the duty is to disclose 15 weeks prior to the due date. One of the things I would advise freelancers to do, all being well, they're in a union, is to talk to a relevant official about custom and practice within that particular workplace, because one of the things that an official may be more familiar with than that particular freelancer is what's the culture in that workplace. Because if it's a problematic workplace with a culture of harassing, dismissing pregnant workers, then yes, you've still got the duty to disclose, but you may want to disclose on the basis that the union knows that you're disclosing. The union is looking at this. It's really, Anna, just being about prepared and aware of a possible negative response from a particular employer, the one that's more, for example, more likely operating in the news media or the entertainment industry. So there is a statutory duty to disclose that's related to the due date. But I think, going back to what Nikki said earlier on about the deep degree of hostility, sadly, that still exists in the UK towards pregnant workers, get some advice from your relevant trade union about whether you should just disclose and everything's going to be fine, or whether you should disclose with the support from the union as well. Hopefully that's helpful, Anna.
Thanks, Ian. Yeah, that does sound like it's a good place to start for freelance union members, is to speak to union about the particular employer in question. We've had a question about someone being discriminated against. They are a rep and they are pregnant. I think our advice in any situation like this, if you are a rep and you're facing discrimination, no matter what it's about, pregnancy or otherwise, is speak to your union, because your union's there to support you. You're their representative in the workplace. So do speak to your union if you'll find yourself in that situation. Okay, I'm going to put a question now to Nikki and to Kate. So we've also been asked, what support is there around requesting flexible working after parental leave? So it's slightly outside what we've been talking about today, but I expect this is an issue that comes up a lot in the workplace when reps are supporting their members. And the viewer adds that with full-time childcare, be it costing what it does, that a lack of flexible working could force some people out of the workplace. Let's go to you first, Nikki, because Kate, I'll give you a chance to have a little rest.
Thanks, Anna. I think I'd be happy for Kate to pick up on the specifics around for the rights of specifically around pregnancy and returning from maternity. But I think in general, as we all know, there is a problem around people accessing flexible working in this country. The government has committed to making it a default, but their proposals are not currently what we would like them to be. So they're proposing to extend the right to request flexible working to a day one right. So currently you have to, if you're an employee, you have to have been in that employment for 26 weeks. They're going to reduce it to day one. But obviously we know that people request flexible working at various different stages of their life and their family's life, and for different reasons, and they're often turned down. I think our research showed that 1 in 3 women's flexible working requests were turned down when they made them, often around, once they become a parent and needing to sort of return to work on a more flexible basis. So I think this again is where we would advise, obviously speak to your union rep and see how they can use the toolkit guidance and the risk assessment guidance to sort of look at how it might impact on your mental well-being, which I would just like to say, I think in the guidance and the fact that we talk about mental health as well as physical health, I think is so important and very welcome. But I think it is part of looking at it from a health and safety perspective, but I think also from the perspective of discrimination in general against often women in the workplace. Flexible working is something that unions can really make the case of. There is currently a lot of ongoing tribunal cases now off the back of the pandemic, really, where employment tribunals are looking at if a woman is turned down for flexible working, is it a form of indirect sex discrimination? Because we know that we live in a patriarchal world that expects women to do more of the care. And so if in turning it down, potentially you are actually discriminating on the basis of a protected characteristic as well. So there's case law there to help you make the case and that kind of thing. And certainly unions are the best place to support people with that. But what I would say is that's why we are campaigning for much better rights around flexible working, because it is still very much in the employer's control as to whether they accept that request or whether they don't.
Thanks, Nikki. And just before I ask that same question to Kate, we will also make sure that everyone who's registered for the webinar receives a link to the TUC's new guidance on flexible working and the things reps need to be aware of on that issue. It covers the whole range of flexible working. It's not just around pregnancy, but there hopefully should be some information in there. Kate, what are your thoughts on information about requesting flexible working when returning from parental leave?
Yeah, I mean, again, echo what Nikki said, that the problem is it's just a right to request. So even if it becomes a day one right, it's still problematic. There are 8 business reasons that an employer can provide to argue against a flexible working request. But the kinds of tips that I would give to people, I think, would be things like, have you got examples, of other people who are working flexibly, whether it's job sharing, part-time hours, and so on. Try and think through all the possible oppositions that an employer or your manager might come up with, so that you can counter them. Make sure you take your trade union rep along to any meetings that you have so that they can help and support you, because obviously it can become quite stressful trying to do this on your own, so it's a great role for reps in helping. Employers do have an obligation to consider requests properly and give you a proper written response to explain why they're turning down your request. So make sure they stick to that and don't just give you some kind of vague response, and then be prepared to counter any arguments that they've given you. And we do have a guidance on flexible working, which is particularly around returning after maternity, paternity leave or parental leave. So again, have a look on the Maternity Action website, because again, that gives you a lot of the legal backgrounds and kind of arguments that you can use to try and negotiate it. But it is problematic. It's something we're campaigning on. It's something that we do get a lot of phone calls from women about because of these problems. And we do try and support them to try and come to a negotiated agreement with the employer. And the final tip, do it on a pilot basis. If your employer is really reluctant, say, well, let's just give it a go for 3, 4, 5 months. And then, hopefully you can iron out any problems and bring them around to your way of thinking.
Thanks, Kate. I think that's a really great tip for lots of things in the workplace. Pilot something first, and then you've got more evidence of which you can make a case. I've got another question for you now, Kate, straight away. What are the increased risks for pregnant women who are employed to work shifts? Do we know any headlines on that? And what then, related to that, would be their rights around reasonable adjustments?
Right. So, well, particularly with night work, I think that's quite commonly understood that can cause a problem. And shift working also can, particularly if it's causing tiredness and stress to the woman if she's having trouble sleeping at night. In terms of rights, I mean, again, if you can get some sort of something from your midwife or GP to explain that you should be removed from night working or shift working, as a reasonable adjustment as part of your risk assessment, then that can be really helpful in terms of convincing the employer to make those adjustments for you. And again, it will be on a temporary basis. You know, it's just going to be for the period of the pregnancy, or while there's particular concerns. So again, I would say that is probably a really good way of trying to get some support from your midwife or GP, and that might sway some employers. But again, this is a problem that we face all the time, in terms of getting employers to make the reasonable adjustments that are needed, and then kind of going halfway or doing very little. And it can be quite difficult to argue against it, but that's what the union rep should be there to help.
Sorry, I was muted there. Thank you for that. We've got we're getting quite a few specific questions coming in about pregnancy itself. So I'm just going to try and take another one here. One moment. Okay, so we've got the situation of someone whose overtime would normally include manual handling. And we've already suggested that manual handling operations might not always be suitable during pregnancy, but the employer isn't willing to put precautions in place. What would the situation be there for the individual? So it's specifically around their overtime rather than their regular job. What advice can we offer people in that situation? I'm wondering who to go to first. Would that be you, Kate, or Ian as well? Let's go to you, Ian, and then we'll come back to the others.
Sure. No, Kate's position on this will be brilliant. I think regardless of whether we're talking about core hours within a contract or supplementary hours within overtime, the risk is still there. The law doesn't distinguish. If and Anthony could have explained this if he was here, the duty still exists whether we're talking about contractual hours or overtime. And manual handling is one of the most significant risks to a pregnant worker. So I would underline something that Kate said earlier on. Before going to negotiate those reasonable adjustments, make sure it's going to be backed up by advice from a medical practitioner. It's what we always do. So whether it's the GP, whether it's a midwife, what you want to do is present something that's non-negotiable. Yeah. So rather than it being the rep speaking, rather than it being the member speaking, although of course the member knows what the risks are, what you need to be saying to the employer is, look, this is the advice from a medical practitioner, and we happen to know that you have a duty to listen to us. Once you've done the risk assessment, we are arguing that these measures, including suspension if needed, Anna, are the way forward here. If the employer is still refusing, then certainly from Equity's perspective, we would then take legal advice about our next step. But I would underline the need to back up any requests for adjustments or changes with medical advice. Thanks, Anna.
Thanks, Ian. I'll hand back to you, Kate, to see if there's anything you'd like to add to that.
Yeah, no, just really reiterate what Ian said. It's a really good way of trying to get some to maybe sort of raise concerns with the employer, so that they suddenly start thinking, well, what's going to happen if something does go horribly wrong? I haven't taken the action that I should have taken. Again, I'd advise people to go to the Maternity Action website and look at our resources around health and safety in terms of our information sheets, not just a toolkit. And there is a model letter in there that you can use and adapt, or your member can use and adapt to write to the employer to demand your health and safety rights. So again, you might find that a really useful resource and template. But I think you just need to highlight, the medical evidence and the fact that there is potential risk, and this should be highlighted by the risk assessment. There's always the grievance option ultimately, but obviously people don't really want to go down that route, particularly if they're pregnant. It's very stressful, but that is another option as well.
Thanks, Kate. That I think, like you say, grievance procedures can be stressful, but it is always there as an option, maybe a last option, if people feel that if a rep feels that might be a situation they want to go down. Okay, we've had quite a sensitive question that has been posted with a trigger warning. So I am gonna put it out there because I think it's quite an important one and probably something that affects a lot of workplaces. Right, so Nikki, I'm going to come to you first on this because I'm wondering if it's something you know that different unions have brought up, maybe at conference or at committee. What support is available to a member who might be pregnant, but then they don't carry the baby to full term? So what support is there, or are we as a union movement campaigning for, that could be provided by the employer? Is this something that unions are talking about and that we want to see changed?
Yes, so thank you for that. So in terms of campaigning from a union perspective, it is something that unions are talking about. So at our women's conference this year, we had 2 motions that we composited, which some of the audience may have been at women's conference, which was around supporting members with pregnancy loss and making sure that they have their rights, like rights to paid leave and that kind of thing, enshrined in law. So it is a campaign area. I don't know again whether Kate or Ian wants to come on this, because I think, and so if I'm wrong, please do immediately tell me I'm wrong, but I think the protections around risk assessments as well would apply to someone experiencing pregnancy loss, or maybe I've got that wrong, but do just clarify that as well. So in terms of things like risk assessments and returning to work, I think that would still count. And I think as well, anyone who is returning to work after that should have time and should have proper meetings and be supported through their union rep and not hounded by their employer to return to work. But we do need more rights enshrined in law to support people who are, and families who are experiencing pregnancy loss, and making sure that when they're returning to the workplace, they are supported. So there is some stuff there around that, comes from the health and safety legislation. But I think in terms of that broader welfare piece and making sure that people have rights enshrined in law, it is something that has come to our women's conference. So is a policy area that we'll be consulting affiliates on and seeing if people have model policies. And that is the other thing that I would say, like, obviously we can campaign for and push for legislative change, but that doesn't mean we have to wait for it to try and negotiate these policies in the workplace. And I do know, and I can see in the chat, people are saying, like, a lot of our affiliates have already developed good workplace policies and practices to negotiate in the workplace around supporting families dealing with pregnancy loss and returning to work. So I think we should be pushing for them, regardless of whether the legislation is quite where we want it or is in place.
Absolutely, Nikki. We can't wait for the law to catch up. So it's really interesting to hear that this was brought up at Women's Conference earlier this year, and that we'll be doing some work on it. We see a couple of people saying that they've already negotiated these policies. It may well be that we ask for versions of these redacted so that we can see what good sample policies look like. Kate, is there anything you want to add to the things Nikki has said around the broader welfare situation of women who experience pregnancy loss?
No, I don't think there's much to add really, but as you say, I think trying to bring about changes to the law is really time consuming, and we haven't got a government that's particularly sympathetic towards us at the moment. So I think going down the route of trying to negotiate a local agreement is probably going to be the quickest and most effective option.
Okay, thanks, Kate. I'm going to ask a bit of a legal question now, which I'm just trying to find, so that they keep moving around in the list. So, okay, here we go. What is the legal definition of maternity? Is it just a period whilst of maternity leave, as the advice might suggest, or is it the status of being a mother, which would be a more permanent state of being? Or do we know the answer to this, or is it grey? Let's go to maybe you first, Kate.
Well, I'm not a solicitor, so our solicitors would probably be in a much better position to answer this than I am. But I think it's from the point at which the pregnancy is confirmed. I wasn't quite sure what the question was. So is it in terms of maternity rights? Or?
The legal definition of maternity, I think in terms of rights, how many weeks or months after, let's say, a return from a period of maternity leave?
Yeah, again, this can vary, and this is one of the areas where we're campaigning, particularly around rights to better protection from redundancy for pregnant women, so that applies up to 6 months after they've returned to work. You know, I mean, I think it kind of depends on the actual nature of the issue that's come up. But there should be some protection from discrimination once you are a mother, once you've given birth and you come back to work. There still could be discrimination on the basis, as I was saying earlier, about women having particular caring responsibilities and that being widely recognised. So it could be indirect or direct discrimination, but it's a bit difficult to generalise, and you know, it's kind of easier to explain if there's a specific example.
I appreciate that, Kate. I mean, it was quite a difficult question, so I appreciate that, you know, there's no lawyers on this webinar and it was difficult to answer, but I just thought I'd throw it out there. We've had another question about shift work, which I think is going to be the last question we're going to have time for. So let me just find it again. And I'm going to put it to Ian first, because I'm thinking there might be more experience of this within equity. So if a midwife or GP recommends that someone switches, for example, from night shift to day shift or between different shifts, would an individual, would someone still be entitled to any enhancements that they got for being on one particular shift over another?
Usually, no. What you're entitled to if you're an employee during a period of suspension is pay at your normal rate, not inclusive of any allowances, any enhancements for overtime. That's problematic, particularly for poorly paid workers, because as many people here will know, many relatively poorly paid workers rely on that overtime and rely on any enhancements that come from it as well. So I think it's really important that reps, obviously we need to pay our primary focus on the health, safety and welfare of pregnant members. But if it looks like the guidance is either for medical suspension or to move to shifts that mean they're not working overtime, making sure the member understands what that loss is financially is really important, unless, for example, as has been illustrated by some of the reps in the room, you've managed to negotiate a precedent in your particular workplace that there is some kind of compensatory element for that loss also. But the technical answer to the question, Anna, is no. The law reverts only to whatever you're entitled to contractually.
Thanks, Ian. One of our viewers has posted in the chat in response to that, saying, what about the element of the law on this that a pregnant woman shouldn't suffer detriment? I mean, I appreciate this is like a huge issue, but I'll just bring you back in in case you want to answer that one. Sorry,
I understand that, and I can see why that particular rep referred to it, but technically that's not a detriment. In legal terms, a detriment is the harm or the impact of some form of discrimination. It is what happens to you as a result of an unwanted act. I understand that it looks like a detriment, but the way that the law is constructed, the only thing that's safeguarded is whatever their hourly or salaried rate is, not an entitlement to whatever the enhancement is through shift work or overtime. Again, I'd ask that rep to consider whether there's been any precedent set by previous cases within a particular workplace, but also to understand the law as it stands, using the resources from Maternity Action, for example.
Thanks, Ian. That was really helpful. Okay, we have very nearly taken a full hour on this webinar, which has been fantastic and really, really useful. We've got through a fair number of questions, but don't worry if we haven't covered every question. We will take them into consideration when we're giving evidence out to reps in the future. So we will make sure that all resources that we've talked about today, and there have been quite a few, we will make sure they're all shared with you in the email that we'll send out along with the recording. And we will make sure that anything we missed from Anthony is included as well, because I really don't know what's happened to him. It's a real shame that he couldn't rejoin us, but the screen was going a bit crazy here, so I think it's probably for the best that you know, technically wise, he didn't come back, even though content wise it would have been fantastic. So this is actually our last webinar for a few weeks. We're having a little break over August and very early September. So we will be back in the early autumn for another busy schedule of webinars from then until Christmas. It's been a really great few months with you joining us all every few weeks for these sessions. We always hope that they're really interesting, and the feedback is always great to see when it's positive. So I want to thank also Ian, Kate, Nikki and Anthony, hopefully you can hear us, for joining us today for a really useful session. And have a great summer break, everyone. We will see you in September for more updates so that we can all make a difference in the workplace. See you later. Bye-bye.